And I believe you can begin with calling the continuance for number 1.
Okay, fine. Good afternoon, everyone. This is Nancy Cameradino, the chair of the board. The first item on our agenda is item number 1, docket ending in 6840 for Alexander Kirstensev. That item has been continued. We're going to turn next to the first of our petitioners to arrive today, and that's for item number 4, ending in docket number 6981. Deborah and Richard Ball. We're getting them into the room apparently at this moment, so hold on.
I don't usually have 3 people. All right.
No.
Good afternoon. This is Nancy Cameradino, chair of the Tax Review Board. If you would identify yourselves for the record, please.
This is Robert Vance. I'm the attorney representing Deborah and Richard Ball.
Okay. And
Ball.
the Balls.
And I'm Deborah Ball.
And this is Christopher Johnson for the city of Philadelphia.
Okay, thank you. I would have gotten to that next, but I need to come back to the petitioners for a moment. First off, I would say if you're comfortable being without the masks, we would appreciate it if you would remove them, because then we'll be able to hear you a little bit more clearly. If you're not, we understand, but would just ask that you speak up in a way that we're more likely to be able to hear what you're saying. And for Mr. and Mrs. Ball, you've already identified yourselves for the record, but do you swear to tell the truth and everything as you're presenting to the board?
Yes.
Yes.
Okay, thank you. Let's see. Does this, you've already identified yourself for the city. Is there anyone who might be testifying with you for the city that needs to be introduced and sworn?
Yes, I have 2 witnesses in this matter, Richard Wade and Thomas Rebikowski.
Are they on the call right now?
They're both on the screen.
On the screen. Okay, I'm sorry. I could. If Mr. Wade could identify himself for the record, please.
Richard Wade, litigation support, license and inspections.
Thomas Rebikowski.
Oh, okay.
Oh, I'm sorry.
I can ask each of you at the same time. Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Yes. Thomas Rebikowski, City of Philadelphia, license and inspections.
Okay, fine. Thank you. You've both identified yourselves and sworn your testimony would be truthful. Does the city have any opening comments before we turn to the petitioner?
I'm gonna just make a preliminary comment about this case, and I think if the board's not familiar with the facts, it's definitely a rare and unfortunate situation in the sense that this was a case where a contractor was engaged by Mr. and Mrs. Ball to do work to repair or replace a sewer lateral on their property. And he did so in an unsafe way that caused the trench he had dug to collapse on him, killing him. And the bill in question here was basically an emergency extraction and abatement of the conditions that he had created on their property. Now, unfortunately, because the code requires that the city take emergency action when necessary, when the code official deems it necessary, and those costs be billed to the owner of the property, that was the result of the bill in question here. So it's kind of, from the city's perspective, strictly an issue that, unfortunately for Mr. and Mrs. Ball, the code requires that when the city does an abatement on a property, the city has to bill the owners. And I would suggest, and this case had been put on hold for at least several listings in order for the Balls to pursue any compensation from insurance carriers and or the estate of a contractor who may have been negligent in performing the services that he was hired to do on their property. They may be unfortunately for the city, the taxpayers paid for an improvement or an emergency response on that property, then they're getting billed. But it could be that they would have some other legal remedy to compensate them for whatever costs associated with the city's services because of this third party's actions. So that's essentially just a preliminary statement before I call Mr. Wade and Mr. Rabikowski to lay out the facts for the board.
Okay, we're going to turn to the petitioner and ask the petitioner to tell us more about their perspective on this and what it is they're asking for from this board. And so if we could turn to the petitioner.
Nancy,
Yes.
I'm so
yes.
sorry. I'm sorry. The numbers for the record, please.
Oh, yes, I am.
Would you like me to
consistent
share
with-
my screen, or Richie, are you going to share your screen?
I was going to share mine if that's fine.
Okay.
Okay, fine. Thank you for the reminder, Melissa. Please proceed with the numbers for the record.
For the property at 106 West Walnut Park Drive. This is a site improvement. Bill date, November 7th, 2018. Bill amount and principal. $73,780.96. Let's broke it down into labor and materials, $60,976, and administrative charge, $12,804.96. Interest to date, $13,280.40.
Gotta be kidding.
The total amount due, $87,061.36.
Okay, thank you very much. Now we'll turn to the petitioner.
Thank you. So from the petitioner's perspective, first of all, the city Department of Licenses and Inspection had inspected the trench the evening before it collapsed and given the Balls contractor the go-ahead to do whatever work he was going to do that they had contracted with him to do. So it's not a situation where the contractor was operating or doing anything in an unsafe manner. He was operating and he was doing work that the city had inspected and authorized him to go ahead and proceed and do. So unfortunately, the trench did collapse, and he was killed by the dirt coming in on him and suffocating him, basically. At that point, subsequent to the collapse, the petitioners through L&I actually, the L&I inspector, Mr. Gallagher, gave them less than 24 hours to try to find a plumber to essentially fill in the trench that was left after the fire department came and did all their extraction to remove Mr. Smith's body. And the cost of, there are two separate bills here, which are somewhat, I don't want to say ambiguous, but there was work done by an outfit called Big Dog Construction, Big Dog Plumbing, that filled in the hole. And then what the city is trying to charge the Balls for is work done by Palmer Construction on the city's own sewer lateral at the street. So it had nothing to do with the Balls property. The work that was done by the Big Dog Company is not being assessed against the Balls, and it should not be, in our view. But certainly the 70,000 or the 60,000 that Palmer Construction that the city is trying to assess against my clients generated by Palmer had nothing to do with their property. It was the city's lateral and the sanitary sewer that this company was fixing. And the bills show that. And that there's two different costs that we're talking about. The Big Dog Construction company bill was about $55,000, and it was this Palmer outfit that had the $60,000 bill, which the bill does not reflect. The bill reflects demolition, which did not occur, but it is for work on the city's lateral sewer that was done in the city street, not on my client's property. So our position is that the bill should be abated 100%, and they don't owe anything to anyone.
A question. You indicate that Big Dog Plumbing filled in the hole. The hole that you're referring to, was that on the petitioner's property? I just want to get a clarification. I thought that's what you said, but I just wanted to clarify that. Were they billed for any of the work on that hole, the digging of it and the filling in of it, or?
No, none of it. Big Dog Plumbing and Heating did the filling of the hole and the landscaping and the repair of the sewer line at my client's property, from my client's property to the street. They were not billed for that. The city is trying to bill them for work done by Palmer Construction, which was not done on my client's property.
And they charge $55,000 for filling the hole?
Big Dog charged $55,000 for finishing the plumbing repair work that Mr. Smith had started, for filling in the hole, doing the landscaping, basically doing everything that the Balls had already contracted with Mr. Smith to do.
And the Balls paid that?
No,
No.
the city paid that. That was Mr.
City
Gallagher.
paid that. Okay, I'm getting
Yeah.
confused because it would seem that it's a little bit backwards.
Right,
That-
exactly. And Mr. Gallagher, who was the city L&I inspector, told Miss Ball the evening before Big Dog came to do the work that he had a plumber, that if she couldn't find a plumber that night, to call him first thing in the morning, which she did, and told him that she couldn't find a plumber. And he brought over Big Dog, and Big Dog Construction did the work. And Mr. Gallagher told Ms. Ball that charge, whatever the charge was for that work, would be billed to the city and that they would not have to pay it, and they haven't been asked to pay it. And so this Palmer Construction, they have no idea who that was, other than it may have been work done the evening of the initial collapse of the trench, but that work was done out in the street. It wasn't done on their property.
I would suggest that the board hear the testimony of Mr. Rabikowski in order to determine what services were performed on where.
Wait, give us a moment. We're hearing from the petitioner right now and maybe asking questions of them. Then we'll be turning to the city for your testimony. Does the petitioner have anything else to add, either through counsel or directly?
I think, just the most important point being, and Miss Ball to my right here had the direct contact with both Mr. Gallagher and another inspector, Mr. Carroll. I mean, she can fill in, the specifics of what she was told by Mr. Gallagher, some of which I've referenced. But I also just want to point out, again, that this is not a situation where the incident itself occurred because Mr. Smith did something he wasn't supposed to do. The night before, an L&I inspector came out and gave the go-ahead to do the work. And in fact, Miss Ball can tell the board what Mr. Gallagher told her the evening of the collapse, when she asked him about, when one of the L&I people suggested that the hole had not even been dug until that morning. I had submitted emailed some exhibits with pictures of the hole the night before the collapse, which clearly showed that the trench had been, was dug the night before or the day before. And Miss Ball can tell you what the L&I inspector told her with regard to the L&I person, and what Mr. Carroll told her with regard to the L&I inspector who looked at the trench.
He told me.
Ms. Ball?
Speak
Yes,
up.
the L&I inspector told me that was the inspector first day on the job that came out and looked at the hole with Mr. Smith. He said that was his first day on the job, so don't worry about that. That's why Mr. Gallagher was gonna make me whole, was the words that he used. He said, I will make you whole. I will fix this for you. And I asked him about the cost, of making me whole, he said, don't worry, you're not gonna be invoiced. Big Dog is gonna directly invoice the city. And he was gonna take care of it.
And this conversation was before the collapse or after the collapse?
This conversation was after the collapse.
Okay, it's been indicated that there was an inspector from L&I there the night before the collapse who gave the go-ahead for the work to continue. Did you talk with that inspector?
No, I did not. He spoke with the plumber that was on site.
So you didn't have direct knowledge of the inspector saying that the work could and should continue?
Nancy, I thought I heard her say that he only was on the job one day. The inspector that inspected the trench. Okay.
I believe was the person she talked to after the collapse. That's why I wanted to find out something more about the person who came to inspect and gave the go-ahead for work to continue the next day.
No, that's not correct. Can you clarify that, Ms. Paul?
No, there was a plumber on site the day.
If you could be a little closer to the mic, which is at the computer, that would be appreciated.
There was a plumber on, not a plumber, there was an inspector on site the evening that Mr. Smith had started the work that evening. He came on site to make sure that everything was okay so that Mr. Smith could continue doing the work that he was set out to do. He gave Mr. Smith the okay. My husband and I was in the house, standing by the window, the door, when the inspector left, and Mr. Smith came in and said, we got the okay, you guys can go to the hotel. We have the okay, we'll start back again 8 o'clock in the morning.
Okay, so you didn't talk to the inspector, but Mr. Smith did, and then
Yes.
came and talked with you about it.
Yes,
Okay, and then it was the next day after the collapse that you spoke directly with an inspector.
I spoke directly with an inspector the night of Mr. Carroll came in, the night of the incident, before Mr. Smith was taken out of the hole, and threatened me that he was gonna fill that hole in within 24 hours. I asked him to leave because Mr. Smith had not even been taken out of the hole. And here, this inspector, through all this traumatic that's happening and that's going on, is telling me about filling in a hole that a man is laying in that's not, that's probably dead.
That he's the one who told you that it was his first day on the job?
No, he said the inspector that came previously.
Oh, the
that
one who
was
came
his first
previously,
day.
the night before. Okay,
Yes,
so that's what, it's important that we get it straight in terms of who said that. So it was not the person who told Mr. Smith that it was okay to go ahead, who indicated to you or to Mr. Smith that it was his first day on the job. That was word from the inspector that after the collapse.
Correct.
yes, that's correct.
Mr.
Do
Gallagher.
other board members have questions?
It's Dominique Ward for the board, but we would agree that this was an emergent situation, correct?
Yes.
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 Okay, so council from the city, what is the standard when there's an emergency situation like this?
Well, hold on. Can I interrupt? Can I interject?
Sure. Go ahead.
What was the emergency? Which situation are you talking about was the emergency situation?
You were billed for an emergency evacuation of the property, correct? After the untimely death of the contractor, which I'm sorry to hear, but ultimately the city provided posting and they went out and actually contracted a removal of all of the debris from the site. That is my understanding of the facts, correct?
No, that's wrong. That's incorrect.
I mean, I would say again that the testimony of Mr. Rabikowski is going to tell us what services would be covered by
Okay.
which bill.
Yeah.
I mean,
Okay,
the
then I
bills
will
them-
await that point. Thank you.
let me, if I can make a point. The bills that the city provided to me, at least, the bill from Big Dog Plumbing and Heating clearly states what work was done, which is the work that was done on the Balls property of repairing the sewer, of repairing their line doing the grading and the filling in of the hole, et cetera, et cetera, et cetera, for which they have not been billed. That is a $55,000 bill. The city is trying to build the balls for a $60,000 bill for work performed by Palmer Construction, and it's just unclear exactly what they did. However, Ms. Ball can testify or can clarify that there was some work going on the night of the collapse, but that work was in the street.
It was in the street.
And it was not work in their yard, and it wasn't work that Mr. Gallagher from L&I had said to her the next day, well, you know, I'm going to make you whole and you won't have to pay for it, et cetera, et cetera. This is work the city did on its own, which was not on their property. It was on city property. It was on the street.
And you're saying that the street hadn't been opened earlier, or had the street already been opened and they continued to do work to finish there in the street?
No, the street was not open. Mr. Smith had dug the trench from the Ball's home to the sidewalk. He didn't go into the street. He didn't get into the street.
And
You
so
know,
when
I think, not to interrupt, but the documents actually show the dollar amounts from these bills. The Palmer construction bill includes the dollar amount of the Big Dog's work that was $55,000. And, you know, what is more, I would probably have to object to the idea that the sewer lateral from the road to the house on their property, which was the job that they had contracted the other guy to do. If it's true, as council is suggesting, that that's a cost borne that should be borne by the city, why would they hire their own plumber to do it in the first place? It doesn't make any sense.
You'd have to ask Mr. Gallagher that question. But the point is, if Palmer tried to include Big Dog, their $55,000, which is in the bill, in the Palmer bill, then that's $55,000 that Mr. Gallagher promised my client they would have no responsibility.
I'm going to object.
So,
I mean,
let me
Mr.
just
Gallagher's
finish.
not here, and that's hearsay. I mean,
No, it's not hearsay. It's called an admission against interest. He's a city employee. So it is clearly against the city's interest for somebody to say, for the city to say, we're going to get the work done and not charge you. And now you're trying to charge her. That's an admission against interest.
Let's contain what you're talking about here to the what the Balls know and what they're dealing with. After we hear from the city and they make their statements on the record about what it is they are billing the Balls for, then we could probably have this kind of discussion. But right now we just want to hear from the petitioner about what happened from their perspective. We'll come back to the other things too. I'm sure that we'll get there, but
yeah, I think she's already testified that about the statement from Mr. Gallagher telling her that
right.
he was going to make her whole. Yeah,
We understand that, but
Okay.
we'll want to hear from the city on it and see whether there's anything else we should know, and then we'll have some additional conversation about it. Do you have anything else to add that hasn't already come up?
Go ahead. Unless you want, go ahead. Do you want to add anything else to what you already said?
Well, like I said, Mr. Gallagher came in and he spoke to me and he told me that I did not have to worry about the work that they were doing.
Right.
And the night before, before he left my house that night, the work that was being done inside the street, he told me that was to secure his drain in the street. That had nothing to do with, he asked me, that had nothing to do with my property.
Okay. Do other board members have any questions before we turn to the city?
No, I want to hear from the city, so that way.
Okay.
We'll have more
Okay.
questions.
George has spoken. I'm sorry, Ryan, or no?
No, I have no questions.
And okay, I guess we're at the point now where we need to turn to the city. And so we'll turn to you. Please tell us more about this matter from the city's perspective.
Okay, I'm gonna call Tom Rybakowski.
Okay.
Mr. Rybakowski, you've been sworn.
Yes.
What is your position with the city?
I'm construction code compliance supervisor, also court liaison for contractual services unit or emergency response.
Are you familiar with the incident, the situation that arose back in 2018 at 106 West Walnut Drive?
Yes.
And have you had a chance to review the department's records as to that incident?
Yes.
Can you tell us, how did that first come to your attention? What happened?
We were called to the location following a collapse of a trench for some plumbing work that was done at the location. Once arriving on location, we found that the contractor who was doing the work, or the plumber that was doing the work, unfortunately had deceased following a collapse of a trench. The fire department made an extraction, and then the city went ahead through contacting our contractor, Palmer Construction, through their subcontractor, Big Dog Plumbing and Heating, went ahead and completed the job.
So let me ask you this. What was the work that was being performed according to the permit issued by the department at 106 West Walnut Park?
According to the department's records, there was a permit that was issued by the department for replace the house trap, house drain, and FAU. I do not know specifically what FAU stands for, or FAI stands for, but there was an issued permit for work that was being done at the property. There was an inspection that took place. The inspector that did that inspection was Inspector Traynor. That is Traynor. And there is notation in our database that an inspection took place on 8/15/2018. In fact, the notations by the Inspector Traynor, are as follows. I received a service request from my supervisor, Ray Gaines. I called the contractor to verify he was ready for an inspection. He said he was ready. I arrived at 106 West Park Ave at approximately 2 p.m. to perform an inspection at a home drain and curb trap, spoke with the contractor, introduced myself as the inspector. The contractor was in the beginning stages of excavation. I explained to him that he's not ready for an inspection. No plumbing work was being performed and no plumbing material on the job site. I informed the contractor to make sure all proper shoring is being used per code, and to call and reschedule when he was ready for the inspection. That inspection took place again on August 15th, 2018. My department, my unit, CSU, received a call sometime later that a collapse occurred at this property, 106 West Walnut Park. I understand that the address or street is mistyped on this data record, but it does match the permit that was issued for this property. My unit got called for a collapse in that the fire department was on location making an extraction. Following those responding emergency inspectors were from this unit, Inspector Carroll, that is Carroll, and the director of the unit, Mr. Gallagher. Following communications by the department, there was communications offering that the property owner engage the services of another plumber to make the necessary repairs. They were not done. The following day, our demolition contractor, or our contractor, Palmer Construction, contacted their subcontractor, which was Big Dog Plumbing and Heating, and they made the repair. In that this property was uninhabitable. It had no water service and it had no drains or lateral as this plumber had disconnected those services. So in order to restore the services and make this property habitable, the city went ahead and made those repairs.
Are you
At this
finished with
point-
your testimony? I have a question for Mr. Rabakowski. The original inspector who inspected it, was he in fact on the job a day prior to his inspection?
I do not know his original employment date.
I believe when you testified a few moments ago, you said that the inspector that came that afternoon said that it wasn't ready for inspection because they were still digging the trench. They hadn't done any of the plumbing work yet. Is that the person who may have been identified as being the one who said the work could continue?
So I have in my notes, I have that the inspector who did the inspection on the building permit is the district inspector, and that would be Inspector Trainer. His notes indicate that he was on location August 15th. We received a call the following day, somewhere around the 16th, maybe the 17th, that a collapse occurred at the property. When we arrived on location, there was no shoring in the excavation. Subsequently, the trench collapsed onto the plumber, and the plumber expired. We ended up completing the job.
I understand that part. The question that I was trying to get some clarification on was whether or not the person who came in that first instance had actually said that it was ready to go ahead. You seem to be saying the exact opposite, that the first inspector there indicated that none of the plumbing work had been done and he wasn't ready to inspect.
From what I understand in the notations in the system, the notations are that they had started the excavation, but there was no plumbing material, meaning there was no piping, there was no actual plumbing work being done. They had started the excavation. So the notations were that they were not ready for a inspection at that time, and to call the district office and reschedule it once they were ready for the inspection of the actual plumbing work.
When is the notations? Were the notations real time or are they belated? When did the notations go into the system?
I have that the notations were done that the date of August 15th. Now, whether or not this notation was done the following day, because he did the inspection at 2 o'clock in the afternoon, so he could have done it the following
that's what I'm
day,
saying.
but I have that he was on location on August 15th.
And what was the date of the actual collapse?
I would like to say the 16th, on or around August 16th.
No, not on or around. All in August.
I mean, if I may, the documents that I've prepared in the packet might elucidate some of this information. And I was going to share my screen and walk through some of these documents.
Okay. From the board, are there any other questions before the city goes on with their testimony?
No, keep going.
Thank you, Dominic. And
Okay, if I may, what can I share my screen?
Yes, go ahead then. I just want to make sure that we asked any questions before you started with your presentation.
Fair enough. Okay. I have the department's packet of evidence in front of me. Now, the first document here. Okay, I'll just make sure I can scroll down. Mr. Rabakowski, I have what's marked as page 1 of the city's packet, and are you hold on, familiar with this document?
Yes.
What is it?
This is a internal document where there was a site improvement performed by Palmer Construction. It's actually written as Palmer. It is a internal document in that it is a notification for work that is performed by a subcontractor for the city at an above location. In this case, it was done at 106 West Walnut Park Drive.
So do the dates have any significance on this document?
In that the date on the, when this form was filled out is September 26, 2018.
And so this is the handwriting of someone at the department, you're saying?
Correct.
I'm going to go on to page 2. What is this document?
This is a document that is filled out by our procurement department. This is filled out by procurement in that it is a notice to proceed in which the procurement department is basically writing a purchase order. That purchase order is DOXX 191-00172, and it is for the property at 106 West Park, Walnut Park Drive, for the site improvement. And that work that was done, the total for that job was $60,976.
And that was approved by who?
There's a signature. I don't know that exact signature.
And the next, this one's marked as exhibits page 3. Is this also part of the same document?
Yes.
How about what's marked as page 4?
So this is the actual invoice from Palmer Construction. It is the document that is submitted into the department for the costs incurred by that contract.
And what are the services that are indicated by this document?
It is that the work for 106 West Park, Walnut Park Drive, plumbing construction, $55,976. There was 8 hours for the truck and transportation of the dirt that was being, or the excavation material for that. So it was another $800, another $200, and then $4,000 for the excavator for the 8 hours of work that was done there. All totaling was $60,976.
Now I'm showing what's marked as page 5. What is this?
Page 5 is the invoice that is submitted from the subcontractor for Pedro Construction, and that was Big Dog Plumbing and Heating. So the plumber who has to do the work, because they are a licensed and insured plumber, for the work that was done, submitted an invoice to Palmer Construction. Palmer Construction went ahead and did their part for the basically filling in the excavation afterwards, and the resulting in the invoice to the city.
And what was the work that was done by Big Dogs?
So the first day that Big Dog was on location was August 17th, 2018. They were on location. It has a breakdown of their time and material. They were also there on August 18th, and it has a breakdown of their cost and material.
And subsequent, I believe that page 6 is also part of the same document. Is that right?
Same document.
And what is page 6 indicating?
Page 6 is that the plumber was also on location on August 20th, August 21st, August 22nd. And then on August 23rd, there are other additional totals for additional work, for the amount of work that was done at the location.
And what was the total?
The total submitted to Palmer Construction was $55,976.
And was that consistent with the bill that the city was issued for the total from Palmer?
Yes.
And this is what's marked as page 7?
This is the invoice that is generated by the department and sent to the property owner of record. This indicates that the property is being billed for $73,780.96. That is following the cost of the invoice that was submitted by Palmer Construction plus the 21% administrative fee that is required that the department puts on any abatement work done by the department.
Now, does the records of the department that you said you're looking at right now, does it indicate when the city went out to do this emergency response at this address back on or about August 16th, 2018, did they designate the property as unsafe or imminently dangerous or unfit or anything else?
We designated the property as unsafe due to the conditions of the foundation where there had been a breach in the wall. The collapse occurred on August 16th. Following at the end of that day, the owner was given approximately 24 hours to obtain the services of a plumber to make the emergency repairs. Those repairs.
So wait, I want to walk back just 1 second and be a little bit slower with what I'm asking. What you just said. There was a breach in what wall?
There was a breach in the foundation wall in that the sewer line had been removed from this property. The water service line had been removed from this property. So we issued an unsafe case in that the property itself had a breach in the foundation. Also, with a property that doesn't have water service or a sanitary line, the property is uninhabitable.
And were the owners of the property notified of this?
They were on location at the time the collapse happened, yes.
And were they given a verbal warning at that time?
Inspector Carroll, who was the responding emergency inspector, was on location. The property had been designated as unsafe.
What was this property ever posted?
I don't know if there was a posting of the property or not.
Did we issue a notice of violation?
Yes.
And I'm going to just share another document here that is the notice of violation. And I want Mr. Rebekowski to be clear about what it says. Okay. So, Mr. Rebekowski, do you see the document I'm showing right now?
Yes.
I'm gonna have this marked and admitted as Exhibit B. What is this document?
So this is a notice of violation indicating the property at 106 West Walnut Park Drive as being declared as unsafe. It is written by Inspector Carroll, and it is indicating that the property is unsafe due to the concerns with the foundation. It is for, it specifically mentions that spells out the location of the violation is the foundation.
Okay. Now, I just want to clarify too, like, as a result of any of the work that was performed to abate that was paid for by the city, did that work comply that unsafe violation?
Yes.
Can you describe how?
Because the plumbing work that had been done breached the the removal of the plumbing work, the lateral and the water service were reinstalled, and essentially the breach in the foundation was repaired. The property was then basically inhabitable and declared safe.
Okay, and just the rest of the city's exhibit packet from pages 8 on, have you had a chance to review these photographs, Mr. Rebekowski?
Yes.
What date were they taken?
So there's pictures in the property on August 16th. August 16th was the date of the collapse and the extraction done by the fire department.
So there's a variety of pictures in the packet, and they show the city's contractors and emergency response working on the property. I'm going to offer the entire exhibit for admission just to document that they were taken and that they show the work being done as alleged. Is there any objection to that evidence coming into the record?
I would object to admitting into the record the photos that are in your packet that show Mr. Smith buried in the dirt. I mean, that's just disgusting, actually.
I would stipulate that, you know, there's no we can have those stricken from the packet if that's what would be preferable.
Yeah, absolutely.
And so I will not show any of those, but do I need to go through each page, or can I reference some of the pages and have the rest omitted?
Yeah, no, I mean, the photos show what they show. There's no dispute about work being done. I'm not contesting that at all.
Okay.
Yeah, I don't have.
Yeah, just for the sake of time, I think I'm gonna go toward the end, and
you gotta go quickly. Yeah, there you go.
Okay, so Mr. Rabkowski, are there photos that were taken on 8/17?
Yes, 8/17 was when the plumber was on location making the repair.
Okay, and was this repair performed on the property at 106 West Walnut Park Drive?
Yes.
And this is a photograph from 8/17, for example. What is it showing?
It shows a small excavator also completing or working on what's a semblance of redoing or making some sort of dig at the location to complete the work.
And just for the record, what Mr. Rabkowski is referring to right now is City Exhibits, page 22. And is that being performed on the property in question?
Yes.
And page 23, again, 8/17/2018.
So this specifically shows the shoring that should have been be placed by the plumber, the plumber that was issued the building permit. This is the shoring that is being placed by the plumber that's on location, Big Dog Plumbing and Heating.
And you say shoring that would protect them from collapse?
Correct.
Okay. And the rest of these, I'm not going to go through them individually. I'm just going to show that these are all photographs from 8/17. How about this one? Is this a photograph taken from 8/18?
This is, yes.
And is this work being done on the premises at 106 West Walnut Park Drive?
Yes.
And what are we looking at?
So this would be on the left-hand side would have been the shoring that's being placed in the excavation. This would be a picture of a plumbing or service or some sort of service in the ground, and it makes reference, or there's some sort of asphalt to the curb line or the street.
And for the record, this is marked as City Exhibits, page 32. Is this underneath the street or is this underneath their property?
This is on 106 West Walnut Park.
And again, 8/18/2018. This is page 34. What are we looking at?
This is on the 18th when the plumber was connecting the new service line. This would be the new sanitary line, the new storm line that are being installed for the property at 106 West Park, Walnut Park Drive.
Okay. I'm gonna quickly move on. That was page 34, all the way up to page 47. That all shows work that was being conducted there on 8/18/2018.
Yes.
Okay. I'm going to stop sharing now, and I'm going to ask that the city's exhibits, both the NOV and also the exhibits packet, be admitted, with the exception of the any photo that shows the body of the contractor that would be stricken from the record.
Okay. If you would identify, or when you actually give them to the board, that way, if you could identify the one that it needs to be stricken, or you could strike it and give us a new batch.
Okay, I can strike those out and submit them after the hearing.
Okay.
Okay.
That would probably be the best, so then we know for sure that the ones that are offensive have been removed from the official record. Does the city have anything?
I'm going to ask a couple of follow-up questions of Mr. Rebekowski.
Okay.
Does the Philadelphia Code address whether a property owner is responsible for water service to the property?
Yes.
And are you familiar, does the code require that the cost of maintaining water service to the property in terms of the plumbing be borne by the property owner?
Yes.
Is that in the plumbing code?
Yes.
Does that include the lateral lines?
Yes.
Was any work that the city had issued a bill to the owners in this case, Mr. and Mrs. Ball, was any of that work related to quote unquote filling in the hole?
Yes.
Okay. And was that a result of any work separately that was done before the work was done?
No.
On the plumbing?
It was all in conjunction with the collapse and the emergency response that was done, being that this property was declared as unsafe, and it was also uninhabitable, being that it had no water service nor sanitary lines.
When council was speaking about the nature of the situation, he was referring to two separate bills. Were they in fact part of the single bill that we were billed by Palmer?
Yes. So you have two separate bills, but one bill was the subcontractor which submitted the bill to Palmer. And because Palmer was the original or the contractor that was called, Palmer submitted a one lump sum bill to the city for the work that was done at 106 West Park, Walnut Park Drive.
I have nothing further.
Do any board members have questions of the city?
Yes, let me ask the city. Was there any insurance company involved in this? The homeowner's insurance or the contractor's insurance or anything?
So this wouldn't be any insurance for the city. This would be something for either the homeowner or their representation to be going after the contractor's insurance for who was issued the permit originally. This was all in response to the property for the emergency that occurred at the property on August 16th following the collapse, and then the emergency repairs that the city took care of to make the property habitable.
So nothing
Go ahead, George.
Nothing happened in that area, right?
I'm sorry, I didn't hear you.
No insurance company was contacted by either by the city or the homeowners.
Not by the city. I can't answer for the homeowner.
Did the city do any work in the street at the same time or as a part of this?
Told you they weren't gonna cover it.
So when you're replacing a sewer lateral and a water service, you have to make a connection to the city service in the street. Sometimes that service is damaged where you have to go further out and the water department has to make that connection. In this case, the connection was made at the curb line where the curb trap was. So everything that was done to the to connect 106 West Park Drive.
Just to clarify, you're saying then that none of the work that was performed on the days after that collapse was done on the city side of the connection. Everything that was done on the property of the homeowner.
Correct.
Any other questions from board members? I guess not.
Can we go to the back for a second?
You want to step aside?
Yes.
Okay, we're going to step into a conference room for a moment and then we'll be back to you.
Okay, what did your insurance company say? They weren't gonna, well, technically, you don't even have a debt at this point.
Right, it was nothing. The insurance company told us, because when they came out, Big Dog and all of us out there working on it, it was, walking around inspecting. They told us it was nothing they could do until they came, till they gave us a, told what they needed to do. Till we told them what they needed to do.
Yeah, because there's no debt at this, point, even now,
Right,
right?
there's
Because
no-
you're appealing this.
Yeah, right.
You don't know anything at
Right.
this point until they make a decision.
But they never told us, well, he was the Thomas Robosky or whatever his name was. They
I'm
never-
not sure if the petitioners are aware, you're not muted at the moment. Just,
Yeah.
I assume if you want to have a private conversation, you may want to be, so I just thought I'd let you know.
I have no idea how to mute.
Mhm.
How do you mute it? Do we just turn it off?
I see George, Ryan, and Dominique. Nancy, our chair, she's kind of fallen off the Zoom, but she's going to try to get back in. Ryan, can you please, oh, hold on, here she is. I think this will allow her in. Nancy?
Yeah, there it goes.
All right, you're back in. Please go ahead.
The board would like to get briefs from both sides on this matter, and particularly from the homeowner. We would like to know about whether you got any information or any support from your homeowner's insurance in regard to this, or anything at all from the original contractor that you engaged, or that person's representatives. So that would be one part of what you would have in your brief. I know we have a lot of things that have already been presented to us by the city, but if they could provide a capsule summary of the key points from their testimony as part of the brief. I'm not sure that we got a discussion at our end about how long you would have. If each side could give us an indication of how long you would need to provide these briefs. I'm thinking of 30 days, but I don't know whether that's something that's achievable.
I concur with 30 days, Nancy. I think that's more than enough.
Thank you.
Are we talking about a simultaneous briefing schedule here?
Right now, we're talking about each of you providing something to us, and then I was going to ask that each side provide a copy of that to the other side as well, so that if there are any comments back that should maybe be within 2 weeks of getting the initial piece, it's best for us to start out with both parties providing something, and then you each simultaneously provide any additional comments, and that would give us about 6 weeks altogether.
The city has no objection to 30 days.
Right. So yeah, I don't have any objection. So just so I'm clear, so we submit our stuff, our brief, our materials within 30 days, and then 15 days after that, we can submit additional information.
No, I think we're
Responding
both going to submit briefs in 30 days, and then we'll have
Yes.
15 days to reply.
That's what I was about to say.
Okay. Yeah.
Your response in each case would be to what the other party provided. So
Yes.
that if you challenge something that the city says, or the city challenges something that you said, we would get the benefit of that shortly after we got the main documents.
Right.
But we think we need to have more information from both sides that narrows down a lot of the things that were already said, and pinpoints things for our consideration on a decision. And we think we would be better served, and you would be better served, if we had a clearer picture from both sides that point out the key factors in.
And Madam Chair, I would like to
Yes.
say specifically whether the homeowner put an insurance claim in against their homeowner's insurance and or the bonding company from the contractor that was unfortunately deceased.
I had mentioned it before, but thank you for reiterating that, because that's something that is not contained anywhere else in the information that we've discussed today.
Could I have raise another question? So I am assuming that you all are ending the hearing at this point? Is that?
Unless there's something that we need to hear that hasn't been raised and or would not be part of the additional submission, I think we were at the point where we thought we needed to have some more written documentation from each side.
Right,
It hasn't been mentioned that we need to get in the oral discussion.
Yeah, I just wanted to, Ms. Ball might clarify and amplify some of her statements. So if it's okay with the board, if you don't want, if I can just, in the submission that I make, just put in an affidavit from her, that
would be
addresses that
appropriate,
issue.
I think, and that way we would have it in writing to review and discuss when the board gets together to consider all of the documentation.
All right.
Would anyone object to an affidavit from Steve Gallagher?
No, but no, we would not. We would not. We would like to hear from him. Unfortunately, he's not here. And he
Okay.
seems to be key to
So that,
many of
I
these.
think we would all like to get any of those statements confirmed if they haven't already been presented to us as part of the documentation.
Right. Okay. So I guess just to clarify things, so by October 16th is when we submit our initial documents, and then or why don't we just say the 15th, and then
I was just going to look at a calendar, and I would agree with you because the 16th is a Saturday, and it would probably be much better to be looking for those documents to be to the board by the 15th of October, if that's achievable.
yeah. So
Okay.
can we say the 15th of October for the initial, and then the 29th of October for any reply?
That would be 2 weeks later.
Yes,
Is the
that's
city in
fine.
agreement with that?
Yep.
Okay, fine. So we'll put that on the record then. We'll look for your submissions no later than October 15th. And then, and if you would share with the other parties so that we can get this ball rolling. If you need additional information, you could share with each other where the documents should be sent.
And I believe we're in contact by email.
Yes.
Okay.
Yep.
Okay, that's fine. And you know where to reach the board.
Yes.
Okay. Anything else to add?
No, nothing from the petitioner.
Okay, nothing from the city. Then thank you very much for coming in today. And we look forward to getting the additional information from you so that we can have as much information as possible to come to a sound decision.
All right.
All right,
Thank you.
we're gonna jump a little bit. Petitioner or attorney, I apologize, for case number 2 and 5 would like to request a continuance. So I'm gonna put him in the room and then we can go to number 3.
Okay, fine. Thank you.
Mhm.
All right. Is she coming to us? Yeah, yeah. I think we have to. All right. Not sure how they're doing anything.
And you can just submit it to the attorney.
I'm in-
George is going incognito. Oh, I see what he's doing.
How are you?
Good afternoon.
Good afternoon.
This is Nancy Camerdiner. I'm the chair of the board. Please identify yourselves for the record.
James Pearl, and this is my client, David Jen.
And this is in regard to dockets ending in 6725 and 6726. Property address is 1427 to 31 South 8th Street. For Mr. Jen, do you swear or affirm to tell the truth with everything that comes before the board?
Yeah, I do.
Okay, thank you very much.
Thank you.
If you would be comfortable without your masks, we would ask you to remove them so that we can hear you more clearly. If you're not comfortable, we would understand. And
So,
we
Miss-
just ask that you project as much as you can. The mic is at or near the computer.
So, Ms. Cameron, so here's my concern. So I've been here about an hour. I've been here for about an hour and 15 minutes. As an attorney, I got a notice that says nothing about you guys being on Zoom, that I could have done it remotely. Normally before the tax review board, I get to see documents, I get handed a packet. I haven't seen anything from the city. I did email Mr. Johnson stuff. I mean, for an hour and 15 minutes, I've been in a room where we're trying to avoid people. And I really feel, and just, I didn't realize you're gonna be remote. And if you're gonna be remote, why wasn't I given that option? When I brought it to the director's, position, she said, oh, I could have gone on the website. I got a notice for a live hearing. That's why I'm here.
Okay, I'm
And
sorry.
let me
about
just
that.
also, so you can, and I'm saying this, today is my holiday.
Oh, I'm so sorry.
So I assumed we're doing a live hearing. If remote, because I would like to be in the room with you, and if you're not in the room, why am I here? I could have done this from my office. So for an hour and 15 minutes, I sat in a room with a mask on. And I have received nothing from the city on this case as well. Usually, through the Court of Common Pleas, when you do remotes, we have to exchange documents 5 days in advance.
I apologize for that. I had sent something into the board earlier today. I didn't
I'm
send it
going
to
to
you.
object to it. I mean, my client's due process is here.
Yeah,
If you're going to run remote settings, you got to tell us it's remote.
I thought our documents that went out indicated that that was an option because we have a number. I can't read it through my screen, but
Well, I'm going to tell you, it says nothing, and it says a lot, hearing scheduled for 9/16/21 at 2 p.m. So I show up with my client.
I apologize, but I personally don't know what the documents are that that have gone out. But we have had have had petitioners who have come in. We've had petitioners who have talked with us remotely. And so from my perspective, I thought we had that clarified. Now that you're here, are you prepared to
Well,
proceed?
I was going to ask for a continuance because
We have no objection to continuing the case.
Well, here's my question. I have seen nothing, no documents from the city to support their case or anything. If Mr. Johnson's going to send stuff, I emailed him twice last week. So am I going to get ambushed here?
Who did you email?
Me.
Mr. Johnson.
Oh, okay.
Yeah, I didn't have all the documents until this morning. So
I mean, come on. I mean, like, I'm a lawyer, he's a lawyer. Like, if I was going to be told it's remote, if I was going to be told that, like, they're going to be using documents.
We generally think or expect that the if there are attorneys involved on both sides, that they would have conversation ahead of time. Most often that's what happens. I don't know what happened in this instance that kept that from taking place, and we apologize. If you would like to have a continuance.
Well, I would like to have a continuance. If you're going to be remote, then I would like to be remote. And I would like to see whatever council sent to you guys. I'd like to see it 5 days, 10 days in advance of the board.
Well, so you're at this point asking for a continuance to consult with the city and.
No, I'm asking for a continuance. Well, let me ask you this question. Is Mr. Johnson going to show you documents today?
I can send them to you right now.
It's not what I asked. If the city is going to offer any documents to which I have not been seen, then I object. So here's my question to the board. I am willing to go forward if you object to him introducing any evidence now.
Well, what I was going to suggest is that the two parties confer and see if you can reach an agreement. If you can't reach an agreement, then you come back to us in a hearing and you could participate.
I have no problem with that. But
Mr. Perlman, excuse me, Mr. Perlman, wait, excuse me, Nancy. Mr. Perlman, please let Nancy finish speaking before you cut her off. Just let her finish talking and then you can speak. We're all civilized individuals. I understand you're frustrated, but this is not a productive conversation if you continue to cut her off.
Go ahead.
I was basically finished because my point, which I will reiterate, is that we would like to see the parties meet together, however you do it, whether it's remotely or in person, and see if you can reach an agreement. If you can't and you want to have a scheduled hearing, we would have a scheduled date established. And then at that point, you could meet with us remotely or in person, again, as you choose. We have not really reviewed any documents from the city or from you, nor have we taken any testimony from the city. We are at ground zero in terms of understanding what the matter is that's before us. And so there's a chance that you could come to a full agreement, or you might agree on some portions of it and the board would only be required to deal with whatever remained unresolved.
Maybe you'll understand my frustration, so we're all clear. I have given the city my documents.
Okay.
So when we're sitting here, just so we're clear, guys, you gotta just let me finish. It's not a case where I have not talked to council.
No,
I sent him
and-
everything.
But what hasn't happened is for the two parties to talk and see if you can reach agreement without coming to the board. Quite often, that's what happens, and we don't even, we get a situation, either a continuous request for the final resolution or a matter that says that it's being withdrawn.
Is nothing lost on the fact that I have given the city documents? That I have not received anything? So when you're sitting here saying maybe the city can talk and maybe council can, I agree. I have done that.
No, you haven't, because you as two parties haven't gotten together, and basically what we'd like to do, the only thing the board can and should do at this juncture is to agree to a continuance. How long a continuance do you think you need in order to exchange documents, exchange ideas, and see if you can come to an agreement?
I was not aware the city had any documents that they were gonna give, because
I have to be honest, I'm not convinced. I mean, I'm pretty sure that this case is pretty similar in a sense to the last case. This was an emergency abatement that happened after an explosion in South Philadelphia did damage to a number of residential properties in around South A Street. And I'm not sure that in terms of, you know, in the board, normally it would be a situation where we'd be talking about settling for agreeing to a dollar amount for the city having performed abatement work at a property. I'm not sure in this case that we would be working toward that sort of resolution. Do you disagree with me?
You're talking to me, Mr. Johnson?
Yeah, I mean, I don't get a sense from your client's position that they would be willing to pay any of the abatement costs, right?
If you're asking me whether the city blows up my client's house, doesn't allow my client to go into the block, and then gets a $72,000 bill? No.
I'm saying that's the question.
Okay, listen, hold on.
So in other words, we're talking about a hearing that's going to probably be a lengthy hearing, and we're not going to settle this case.
Hold on, Mr. Johnson. This is Board Member Boyer. What we're going to do is we're going to continue this for as long as the chair says, and that's it. We're not arguing this case. We understand your frustration, but right now we're going to go for a continuance. Nancy, how long do you want the continuance to be?
60 days.
When can we? I'm sorry.
How about 60 days? We'll put a continuance for 60 days.
That was where I was starting to head. We have are of like mind. So we're going to continue this matter for 60 days. We encourage
I concur.
together and see whether or not you can reach a decision, or if you can come back to the board with a capsule summary of each of your positions. We'll be scheduling for sometime shortly after the 60 days. If you should reach a decision when you meet, whether you and how you meet is up to you. But if you should reach a decision that results in not having to come back to the board, we would appreciate it if the petitioner would withdraw the petition and let us know that we shouldn't be putting a time on our agenda for this matter.
Okay, can I just ask two clarifications? You're automatically going to give a 60-day continuance, so there'll be a new hearing?
Yes. Yes,
Okay.
we wouldn't reschedule until at least 60 days out.
That's fine. Okay, so sometime in November, it's fine. And can we get whatever the city was going to offer? Can they email it to me in the next 2 weeks?
I think I would suggest that the two parties try to get together. However you do it, whether it's by email, if it's remote, if it's in-person meetings, that is between you and the city. We're encouraging.
Nancy, this is Melissa. Yes. Please direct Mr. Johnson to email Mr. Pearl the required documents within 2 weeks so we can move.
I'm emailing him as we speak.
I'm sorry to interrupt, Nancy, but please, he's just asking for the board to order Mr. Johnson to provide him with
Okay.
the documents that he needs. So
Okay.
how about, Mr. Johnson, can you please provide it to him in 2 weeks?
I'm sending him the packet I sent you earlier right now.
Perfect. Nancy, you had to make a decision here.
Okay,
I'm sorry.
I'm sorry.
We will be sending you a letter in the mail, Mr. Pearl.
Great.
You can
Thank
attend the meeting by Zoom. The link is on the TRB website, okay?
Thank you. I appreciate
No
it.
problem. All right.
Okay,
Our next
thank you
case
very
is
much for
number
coming
3.
in, and I'm sorry about your frustrations.
Thank you. Thank you.
Our next case is number 3. One moment.
Okay, thank you.
What?
Thank you, everyone. Have a good weekend.
Thanks, Tom.
You're heading out? Thank you.
Hello, everybody.
Good afternoon. This is Nancy Kamerdiner. I'm the chair of the board. Please identify yourself for the record.
Sami Mustafa, Azab LLC.
Do you swear or affirm to tell the truth with everything that comes before the board?
I swear.
Okay, thank you.
You're-
Who has this matter for the city?
Ellen Corrigan on behalf of the city.
Do you have any support people who will be testifying who may not have already been sworn?
Yes, I believe Mr. Higgins has not been sworn in yet.
Okay.
He
Please
is-
identify
he's-
yourself for the record. Is he on?
I'm
He
here.
is-
Okay, please identify yourself for the record.
Martin Higgins, Community Life Improvement Program.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, thank you. Does
want
the
the
city have
numbers?
any open comments before we turn to the petitioner?
We can read the numbers into the record.
Okay,
Um,
that's important.
I'd also just ask, the property is owned by an LLC, so I'd also just ask Mr. Mustafa what his role is with the LLC.
I'm the owner.
Okay.
Who's going to read the numbers into the record?
Richard Wade litigation support, license and inspections.
Okay, and you were sworn earlier.
Yes. This is for the property at 6,000 North Hutchinson. The clip abatement, bill date, August 14th, 2020. Bill amount principal, $1,344.31. It's broken down into labor and materials, $1,111. Administrative charge, $233.31. Interest to date, $87.36. Total amount due, $1,431.67.
Okay. Does the city have any other opening comments before we turn to the petitioner?
Just briefly, this is a fairly standard clip case. The property was cited with a notice of violation found to have a significant number of trash, including a number of tires stacked up, which can be a fire hazard. So after the certain amount of time that the violation was not remedied, Clip went out and did clean up the property for which the bill was issued.
Okay, thank you. Let's turn to the petitioner. Please tell us why you're here and what it is you're looking for from this board.
I got this lot last year. And I started cleaning, me and my wife. We clean it very hard. The tire, I clean it and I move the tire. I'm the one I move the tire, I'm the one I move the trash, and I have receipt where I take my tire and my trash. Also, if you go now, you will see more tires, more than you saw before. And I keep cleaning this lot, very special lot. It's an apartment back there. Everybody leave or move from the apartment. He leave his trash there. Also, most important thing that I do not own the whole lot. I have a tiny piece in the lot. I do not have the ticket I have or the violation I have about obstruction in the lot, the whole lot. But I have very tiny piece in the end of the lot. I keep cleaning before Ella and I go there. Even while she was working there, a week before I was there, the neighbor told me, all the neighbor in the area know me, that I keep cleaning this lot. This lot is not a regular lot. You clean it and go. No, every day they dump trash. Ask anybody in the neighborhood. I have proof. I can get you signed paper from the neighborhood. So I'm not asking for any, this is unfair to pay for the whole lot. I have tiny piece in the lot. I keep working in the lot. I have proof before and after. That's my piece of the whole block. That's piece. Ella and I demolish a house here. I hope they're not charging me for something not belonging me. Okay, they clean the whole thing. But I have one piece here. I clean it. I keep working on it. Even when they went there, they never tell me they were there. The tire is still there. More tire. It's a place, hiding place where everybody throw away his tire there. I pay for this tire. I have proof that I pay to move a lot of this tire. Ask the neighbor. Anybody in the neighbor know that?
Sir, can I ask a question?
Sure.
When you say you only own part of the lot,
Yes.
do you mean part of 6,000 North Hutchinson, or do you
Yeah,
mean there are
6,000.
other?
6,000. I own 6,000.
You
I
own the
own-
whole
No,
6,000?
not all. Not only 6,000. But the block, they clean the whole block. Not only clean 6,000. 6,000 is a very part of, small part of what they clean.
So
You
we're
understand?
only, and our case is only for your lot. I'm just trying to determine where you're saying your lot.
My lot
begins.
here. The
I
L and I,
can't
they
really
clean
see
the
that.
whole, huh? This is my
I
lot.
can't,
We
Ah.
can't see, when you hold it up like that, we can't see what you're pointing out.
My lot. You see it? They clean the whole thing. There is house there, they demolish. There is
Okay, but
around 25 cats in
So
here.
can I ask you a question, sir? Your lot is obviously the corner lot because it's 600.
Yes.
Did you think about putting up a fence?
I will after I clean it, because I was in the middle of this. I will do that. Promise. I will do fence, but there is a lot of clean in this lot because next to it, it's apartment. They throw away everything there. The street next to it, I'm the one I clean it. Everybody parking there now. Me and my wife. I have a picture I can show it to you if you give me a minute.
Excuse me just a moment. With your petition, you submitted some pictures that show a before and after.
Yes.
And so the question that I have for you is there, we can see with the before picture that there are tires and there are other things there. And this is specifically on your property, not the whole block. Is that correct?
Right now, I move it from my property, but next to it, it's more than 100 tire there. I just came from there. I'm every day around the area.
But I'm only asking about your property because your property is the only thing the city should be focusing on here in terms of any bills for you in terms of the cleanup. And my question is that you've given us pictures that show what was there on your property before and then how your property looked after you cleaned it. And so the question I'm asking you is there any way we can tell from the pictures you've already given us or information that you can provide to us during this hearing to help confirm that what you cleaned and what these pictures represent were actually cleaned by you and not pictures taken after the city came and did the cleaning? Do you understand what I'm asking?
I do. Okay. Yes, I do. I want to show you something. Can you see all this trash?
sir, is this from the packet you provided to the court?
Yes.
Okay,
I
so
can
we
actually share that screen if the court would like. to
Yes.
make it easier for everyone.
Okay,
Yeah.
can you?
Okay,
Okay.
that try, no,
She's
she's
a-
gonna, you've already given us pictures. She's gonna put them on the,
Okay.
on
Okay.
the screen. Except
Okay.
we've got something for a breakout room. Do we need to? I would say not now.
Okay.
No, I still think he's trying to show stuff.
Is this what you're trying to show, sir? What's on the screen now?
Not the color one. Okay, you see, 1 second. You see all this trash bag? You see the street itself was full of trees. I cut it myself, not the LNI. In the curb, I cut maybe 5 trees in the curb before I go in. Before I go to the lot, this is the curb. This is the curb where it used to be. That's me and another friend with me over here. Another day I didn't get picture. My wife who was with me. I'm clean. You see the guy over here? He's cleaning. I pay for this guy. I
Sir,
pay for the dumping trash.
may I ask,
This
are
is before.
these pictures time-stamped at all?
Say one more time.
Do they have timestamps on them to show us what date and time they were taken?
Okay. Yes.
Because I don't see that in the packet.
That appears to be the point of dispute. The city says they cleaned it and that they took these things, and you're saying that you cleaned it. And so
I clean my lot. The city. I clean my lot. The city cleans the whole block.
If I may,
Whole area.
while
right now,
the
we're only
city,
concerned with your lot.
Say one more time, please.
while the city may have cleaned more than one lot, we do not bill you for the other lot, sir. You were billed only for your lot. We are not discussing the other lot today.
The only thing is the city do it in the top of the lot. They cut some trees, but the trash, the tire, I do it. And this bill come while I'm in work. I'm working in the lot. While I'm working in the lot. You understand me? So I clean the trash, all the trash I clean it, all the tire I clean it. The city did not take any tire from my lot, never, no take any trash. The city might cut some trees, that's it.
And excuse me, did you have these pictures that show the things that you've bagged and piled?
Yes,
Did you then remove them from that area and dispose of them at an appropriate trash disposal?
yes, I
location?
did. Yes, I did. I did myself.
And do you have anything that shows when that happened in relationship to when you gathered the stuff together? Do you have any
I think
documentation either with your pictures or separately?
did also the date before all this, before even the city go there, I was cleaning there. Okay, 600, 26, 1, 26. I think I printed it this time, but
Okay.
in the other side, they have more tire.
Again, we're not speaking about anything but your property,
Okay.
sir.
Okay. Okay.
Not to interject, but can we actually hear the city's presentation of the case following this
Thank you.
photo array?
I think.
Thank you very much.
I would agree. I think
Yeah.
we need to hear from the city and then we'll see if we have any further questions. Thank you, Dominic.
The city calls Martin Higgins to the stand.
The city, what? I'm sorry.
Calls Mr. Higgins.
Oh, okay.
Sorry about that, I'm here.
Yes. Hi, can you please introduce yourself and your title for the record again?
My name is Martin Higgins. I'm Code Administrator for the Community Life Improvement Program.
And in your role, have you had the opportunity to review all the files associated with 6,000 North Hutchinson Street?
Yes.
Okay. And if I may share my screen again, the city has provided this packet previously to the board. I'm happy to forward it to to Mr. Mustafa as well. But if I may bring everyone's attention to what has been labeled as Exhibit B. Can you please identify what's been placed on the screen?
That's the notice of violation that was generated on May 29th, 2020.
And are these notices of violation generated in the standard course of business?
Yes, they are.
And what does the notice require in this particular case?
It's referring to 6,000 North Hutchinson Street being a vacant lot, that it was in violation of the code and that you needed to make the necessary repairs by June 11th of 2020. You could also contact the office and the inspector, Robert LaPenta.
To your knowledge, was any appeal of the violation filed?
None, not to my knowledge.
And then if I may move down to what has been marked as City Exhibit C. I don't know why these have changed sizes. Sorry for that. I'm going to zoom in a little bit. Can you please identify what it is that is being presented now?
It's the sidewalk area of 6,000 North Hutchinson Street.
Okay, and do you know when these pictures were taken?
Looks like August 13th of 2020.
And does the Community Life Improvement Program or CLIP take pictures in the standard course of their cleanup programs?
Yes, they do.
When do they usually take those pictures?
They take pictures before the cleanup's done, after the cleanup's done. They also take a picture when the notice of violation is generated, as well as when a reinspection is performed.
And then I'm sorry for the inconsistency. I don't know why they came out slightly different sizes, and I apologize. And then if I may move on to what has been labeled as Exhibit D. Can you please identify these photos?
They would be photos of the property after the work had been done by the crews.
And is there a date on these photographs?
Yes, August 13th, 2020.
So is it pretty standard for CLIP to take pictures before and after in the same day they do the work?
Yes, yes, it is.
And will the crew that is sent out, will they do that generally all in one go, take the before pictures, do the cleanup, and then take the after pictures?
That is correct.
Okay, thank you. And then finally, if I may present Exhibit E, can you please identify this for the court?
That is the abatement bill for the work that was done.
Okay, and does that include both the principal amount and the administrative fee?
That is correct.
Thank you. And this was sent to Mr. Mustafa as the owner of the property, correct?
Well, it was sent to the LLC, but it is at the address labeled as 128 Cottage Ave in Morristown.
Right. The city believes that we have sufficient evidence to show that this work was performed. As you can see from these photographs, again, I understand that Mr. Mustafa may have done some cleanup at some point, but at the time that the violation was sent out and that CLIP went out there, you can see there was significant trash, significant buildup in the property. And on the same day, CLIP removed all of it. The city performed this work. The taxpayers have already paid the money that's required for it. And we are now billing Mr. Mustafa through his LLC as the code requires.
Coming back to the petitioner, the information that you have discussed with the board did not have a date associated with it. Do you have anything that shows what date you did your work? Or after hearing what the city had to say about how they took the pictures same day with their before and after shots, do you see now that you may have worked on days different from the one that was billed to you? Is the petitioner still on?
Yeah, me?
Yeah. Did you hear my question?
Yes, yes, yes.
Do you know what date it was that you were doing the cleanup and the pictures?
I want to say, mention something, that the letter for the violation asked me to correct the problem. It came long time after the whole story is done.
Okay, but my question to you is, do you have anything that would confirm what date or dates you did the work on
Okay.
your property
Okay.
in
Okay,
conjunction
yes.
with that, responding to that violation?
Okay, okay. Before I arrived, the property was missed. After I got notice on October 14, my son and I went to clean the lot. I removed the tire, took out the trash, out down multiply trees, and was in the process of
And
doing
again,
more.
that date, that date again was
October
what?
14. October 14.
Of what year?
What year? October
Did you say
14.
14, October 14? What year?
October 14.
What year?
2020.
Okay, coming back, if I may ask the city, what, again, was the date that you were representing as a result of the violation notice?
The work was done on August 13th, 2020.
Okay, so the work that the city did was in August. The work that you're referring to was in October. Did you also do work in August, or are we talking about two different time periods here?
I have more than a lot, and usually as soon as I get the lot, I start cleaning and put fence. This one is different. It's different.
Okay.
I work in the lot all the time. I work, but this lot is disaster.
Okay.
It's different lot than any lot.
Do you do the work? Have you done this kind of work to clean up multiple times over a period
I
of
did.
time?
I do. I did. A month ago, I was there.
Okay. Do any of the board members have additional questions of either the city or the petitioner?
No, I don't have it. No.
Anyone else? Should we go to our breakout room?
Please.
Okay. I think at least I see something up on the screen to achieve that. Does everyone else have that available?
Yes. Okay, the board is, I'm putting the board in the room now.
Okay.
And excuse me, Mr. Higgins,
Yes,
could you just repeat your title again with the city?
sure. It's Code Administrator,
Okay.
Community Life Improvement Program.
Okay, that part I missed. What is it?
Community
Okay.
Life
Community
Improvement Program.
Life improvement. Thank you.
No problem.
Okay, we're just waiting for Nancy. Perhaps, George, you can read the decision for me, please, if you remember it. George? Oh, you're on mute, George.
I don't have the final number we talked about.
Okay.
70, it was 75%. I mean, we cut, you know.
Okay. Well, I'm waiting for the chair. She's taking a bit to come back. Okay, I'm gonna read the decision into the record because our chair is not in at the moment. But if all the board members can agree with the decision as I read it, I think that will be okay. The board agreed to abate 100% of the interest, 100% of the administrative charge, and 75%.
25%.
25% of the principal. I apologize. And that the petitioner should arrange installment agreements within 60 days. Board?
Yes, I concur.
I concur, Ryan Boyer.
Dominique Ford concurs.
If one of the board members can read the appeal rights to the petitioner and city. Or not.
Oh, 30, okay, so 30 days after you receive the notice, you can actually appeal the decision that you're gonna receive in the mail.
Correct.
I thought Nancy was on here. Sorry about that.
She fell off. I apologize, sir. Her chair fell off. So you'll have 30 days to appeal this decision to the Court of Common Pleas if you disagree with the decision. Same applies to the city. You'll get a decision within 2 weeks. It'll be mailed to your home. And of course, again, 30 days to appeal. Okay? All right.
Okay.
I'm going to continue on with being chair for right now. And this meeting is adjourned.
Thank you.
Thank you.
All right. Have a good day. Thank
Bye.
you.
Yeah.
Maybe excuse, this is my only hearing.
Oh, yes, we're done. We are done.
Thanks.
Thanks, Marty.
Yep, have a good day.
Therese, thank you very much.
Okay, you're welcome.
George, thanks again.
Thank you.
Bye.
Bye.
Thank you, Dominique.
Adios.